Wealthy litigants bring their legal business to London's Royal Courts of Justice from all over the world, attracted by the reputation of Britain's judges for incorruptibility and fair play. But in 2021, two of this court's top judges sent emails we believe show they may have been involved in a miscarriage of justice. And when we asked them about those emails, their spokesman gave us a story we don't believe is true. We are Hunt and Gather, and you are watching The Other Night. Hello. The programme you're about to watch is the culmination of a long-running investigation into the conduct of two senior judges in London, and how we here at Hunt and Gather Reporting and Video have formed the opinion that they have broken their own rules. It's also about the story we were told by their own spokesman when we put our findings to them, and why we don't believe that that story is true. Mrs. Justice Sarah Cockerell sits in the Commercial Court. Lord Justice Sir Stephen Males is a judge in the Court of Appeal. Before I explain what we've uncovered, we just want to talk about the concept of independence as it pertains to the administration of justice. If you've ever sat on a jury, or if you've sat in a dock and been convicted by a jury, you will already understand what independence is. It's the reason that jurors are warned over and over again throughout a trial by the judge not to talk to anybody else about the case they're hearing. That's to safeguard their independence. They have to decide the case based on what they hear in court, and only on what they hear in court. If they go home and talk to their husbands, their wives, their children, their friends, if they go online and research the case, they destroy the independence of the entire jury on which they are serving. That's going to lead to a mistrial at best. At worst, it's going to lead to a miscarriage of justice, and an innocent person could go to jail. Now, in a case where there is no jury, the judge hears the evidence alone, they make a decision alone, and that requirement to ensure independence falls on them alone. In fact, the judiciary is so keen on the idea of judicial independence, there is a whole section about it on their website. It is vitally important in a democracy, it says, that individual judges and the judiciary as a whole are impartial and independent of all external pressures and of each other. As well as in fact being independent in this way, it is of vital importance that judges are seen to be both independent and impartial. Justice must not only be done, it must be seen to be done. But we have obtained two emails written by these two judges on two separate days in 2021 that show they were both talking to somebody else about a case while it was going on. We believe by doing that, they compromised their independence and so interfered with the proper course of justice. We're going to show you those emails, then we're going to tell you what the judge's own spokesman said about them, and then we're going to explain why we don't believe that that is true. On the 26th of April 2021, Mrs. Justice Cockerell handed down a judgment at 10 o'clock in the morning. At 10:06, she sent a copy by email to somebody with no professional involvement in the case. This man, Duncan Matthews, he's a barrister at 20 Essex Chambers. It's an email with the subject line, "A heads up," and it's an email that the public and the parties to the case were never meant to see. Now, Mr. Matthews is a lawyer, but he wasn't involved in this case. He is, though, apparently an old acquaintance of Mrs. Justice Cockerell, who says here she has known him since about the first day of pupillage, which is something barristers usually do in their early 20s.
The judge already knew when she sent this email that the losing party was planning to appeal because she had had this from their legal team the previous working day. It asks her to extend the deadline for filing their appeal. And you can see from her clerk's reply that the request was received and forwarded to her. So as she typed the email to Mr. Matthews, she knew that the case was ongoing. Now, these judgments are all available online. Duncan Matthews could have gone and found it himself, as we have done here. Instead, he gets a bespoke notification within minutes from the judge herself, a judge he has known personally for many years and who already knows that there is an appeal in the pipeline. Now, when you lose a legal case, the right to appeal isn't automatic. You have to get permission to do so from a judge. And in this case, Lord Justice Males was selected to decide whether the losing parties would get that permission. But before he does that, Duncan Matthews goes and meets with him. They discuss this case, and permission to appeal is then denied. We know this from the second of the two emails that you, the public, and the parties to the case were never meant to see. It's an email written by the Lord Justice himself to Duncan Matthews, in which he talks about that meeting and about their discussion of the case. "It was a pleasure to see you the other night," he says, "and to catch up on your and Chambers' news. I did not want to say much then about the case of versus as I was conscious that I had an application for permission to appeal to deal with and wanted to ensure that I approached it with an open mind. I have now refused permission to appeal."
Right, so there's an appeal court judge talking about a case with a man we already know has been emailed about it by the first instance judge. Now, these two judges are supposed to be completely independent of each other for their decisions to be lawful. He didn't want to say much, he says. The question is, why was he saying anything at all about a case that he'd already been assigned to? The two judges are on first name terms, and he says he is aware that Mrs. Justice Cockerell has already mentioned the case to Duncan Matthews. Well, how and why is he aware of that? Did Duncan Matthews tell him, or did she? It's really not clear from this email, but if it was my case, that's something I would want to know. Remember, it is her decision that could be overturned if there is an appeal. She shouldn't be involved in this process at all, but the appeal court judge is already aware that she's been talking to somebody else about it.
We've had to redact some of this for legal reasons, but for us, it does have the feel of someone reporting back. "You will see how I dealt with this," he says. He ends by saying that something else needs to be dealt with, and that he is sure that Duncan Matthews will take the appropriate steps, though it's not clear to us from this email exactly what he's talking about. And like Mrs. Justice Cockerell, he also attaches a copy of his judgment for Duncan Matthews. But there are a few things to note about this document. First, it's an editable Word document. When these permission to appeal decisions are emailed to the parties through the proper channels, they are sent as PDFs. Let's take a closer look at this now and compare it to one that was issued through those proper channels on the right of your screen. You can see from looking at the first page that the one on the right has been drafted on the same form as the one that Lord Justice Males sends to Duncan Matthews. The finalised PDF has two stamps, a shield in the top right-hand corner and a circle in the middle. The box containing the judge's reasons is much longer on the Males decision. It runs into a second page, but it is followed by the same sections for information and mediation. There is then supposed to be a court signature, the date, and the name of the judge. But the signature and name have not yet been added to the version Lord Justice Males sent to Duncan Matthews. Both the Word document and the PDF have identical notes following the date, And the PDF ends with this backsheet, which records the solicitors and firms to whom the document has been sent, information we have redacted. That backsheet is missing from the version Duncan Matthews gets, but it has something extra. This is an internal Court of Appeal form included so that Lord and Lady Justices can issue instructions to office staff about how the appeal is to be handled. It is usually removed by those staff during the publication process, which is why it does not appear in our example on the right. So not only is Lord Justice Males sending Duncan Matthews a document he has no business seeing, but he's sending him a version of it that the parties to the case never even got to see. So Mrs. Justice Cockrell hands down a judgment and emails Duncan Matthews a heads up within 6 minutes. Lord Justice Males is selected to rule on permission to appeal, Duncan Matthews meets with him, and permission to appeal is denied. The Lord Justice then reports back to Duncan Matthews with an internal office copy of his decision. He is also aware that Mrs. Justice Cockrell has spoken to Duncan Matthews already, raising the question of whether there has been direct contact between the two judges about this case.
Now that triangle of contact shows very clearly, in our opinion, that the independence which is demanded of the public when they sit on juries has not been safeguarded here by these judges. Lord Hope of Craighead summarised the law on this very neatly in a speech at the University of Birmingham in 2010 when he was Deputy President of the Supreme Court.
That speech is about precisely this issue. Judges aren't allowed to talk about their own cases outside of court, not even once they're over. The golden rule, Lord Hope says, is that judges do not discuss individual cases.
So why are not one but two judges discussing this case? Once we'd read these emails and understood their implications, we had a number of questions about them for the Ministry of Justice. One, why were these judges breaking that golden rule? Two, how did Duncan Matthews even know that Lord Males was deciding this permission to appeal? That's not something that anybody is supposed to know.
Under international law, judges should be allocated to cases by a predetermined system. Given the random manner in which cases are lodged, that should make it a random process, a bit like dealing cards. A case comes in, the next judge is peeled off the top of the deck and put on it, unless there is a reason they shouldn't be. At the permission stage, only the judge should know that he or she is considering a particular set of papers. That makes the application of external pressure to their decision impossible. Yet Duncan Matthews knew Lord Justice Males had been allocated this case. Someone must have told him about this judicial assignment. Who told him, and why, and what was his interest in it? And was that interest related to the heads-up email he'd had from someone else?
And the third thing we wanted to know was what exactly was going on at this meeting the other night between Lord Justice Males and Duncan Matthews. Who else was there the other night? Were notes taken the other night? Were the parties told that the judge considering permission to appeal in their case was talking to someone the other night about it? Was he given any information that hadn't been relied on in court the other night? Now, the next part of the story is about our attempt to get answers to those questions from the Judicial Press Office and why we don't believe that the answers they gave us are true.
We'll cross now to Westminster, the beating heart of the British government, where you will find tens of thousands of civil servants hard at work. One of them is Michael Duncan. He's a senior press officer in the Judicial Office, which is part of the Ministry of Justice. And I wrote to him about all this on the 19th of April 2022. I explained the apparent triangle of contact revealed by these emails, and I asked for an official statement to include information regarding where the meeting between the Lord Justice and Mr. Matthews took place, and who else was there when the case was being discussed. Now, you might think that those two questions would be pretty easy to answer after a brief conversation with the judge, perhaps. But as April wore into May, the answer from Michael Duncan was a long time coming. When it finally arrived on the 10th of May, it said this: Duncan Matthews is the head of chambers that one of the counsel in the case is a tenant, and the contact with him was in a professional capacity, and there was no discussion about any details of the case.
Well, that just didn't make any sense to us, and it didn't answer our questions either, such as where did this meeting take place? He seems to be saying that Lord Hope's golden rule was broken because one of the barristers on the case was at Duncan Matthews' chambers. But the barristers on a case are always at someone's chambers. He also says they didn't discuss details. But how do you have a discussion in a professional capacity about a case without discussing details? Besides, Lord Justice Males had already said there was a discussion about the case. I didn't want to say much shows that he had said something. We were trying to find out exactly what, and the Ministry of Justice didn't seem to want to tell us. So we wrote back asking for clarification.
That was on the 17th of May. We called Michael Duncan several times as spring rolled into summer, but he didn't call us back. Now, he wasn't just being lazy. We later found out he was taking instructions from Lord Justice Males, and we'll come on to the emails that were going back and forth between them at this time in another episode. Suffice to say for now, though, that by the 8th of June, we'd had enough of waiting. And we wrote to him again, explaining in more detail our concern about that meeting the other night. The first instance judge was in contact with a third party about a case on April 26th, we said. And that same third party was meeting with the appeal judge in July before he made a decision about permission to appeal, and discussing the case in an out-of-court setting. Is the court service completely satisfied that this triangle of contact has not compromised the independence of this appeal? And this time we asked who paid the bill for dinner or drinks, if there had been a bill, at this meeting the other night.
You see, if hospitality was being enjoyed by a judge while he was discussing a case, that could potentially engage elements of the Bribery Act. Now, I don't know if it was that particular question that got his attention, but when I asked it, Michael Duncan finally got back to me.
That was on the 9th of June. He said he would look into it. I chased him again on the 10th, the 13th, and the 20th.
Finally, later on that day, I got what was meant to be an answer to my questions about the other night. Now, bear in mind, I'd been asking them since the 19th of April, and it is now the 20th of June. I was told, Lord Justice Males and Duncan Matthews QC both attended a large dinner of the Commercial Bar Association. It is not unusual for judiciary and barristers to attend the same event. As here, judges are therefore careful not to discuss the merits of cases which are before them. A large dinner of the Commercial Bar Association. So now, after 2 months of asking, we've got an answer, but it's completely devoid of detail. It didn't answer any of the questions we'd asked: where the meeting was, who was there, most importantly, what was said, whether there was a bill, and who paid it. Mr. Duncan added, if you are using these statements, could you attribute them to a spokesman for the judiciary?
Compare this with what he said on the 10th of May. Then the discussion between Lord Justice Males and Duncan Matthews was in a professional capacity, no mention of a large dinner. Now he is saying the two men just happened to be at the same event, hosted by someone else. These are two different accounts from the same person, a few weeks apart.
Lord Justice Males' email was sent on the 28th of July. Now, the other night means when? 3 nights before? 2? It's not clear from that email, but here's what was going on in your life in July 2021.
The UK was being blitzed by a relentless firestorm of headlines like these about the dangers of COVID. All of these are from that July. If you don't like the Daily Mail, go to your favourite newspaper website and you will find dozens of similar stories from that month. I asked the administrator at the Commercial Bar Association, which is known as Combar, for the exact date of their large dinner, and she told me it was July the 22nd.
Well, this was the Prime Minister on the 18th.
Hi folks, like so many hundreds of thousands of other people across the country, I've been pinged, I've been asked to self-isolate by the test, trace and isolate system after I've been in contact with somebody who has COVID, in this case of course the Health Secretary Sajid Javid.
On the 19th of July, the day after he was speaking, we were due to move out of the final stage of lockdown. This was the guidance that was in place for that. It's a new phase of continued caution, we were warned. The pandemic is not over. Cases are increasing rapidly and a third wave is underway. Step 4 does not mark the end of the need for caution and restraint. Cautious guidance will remain, making it clear this is not yet a return to normal. While cases are high and rising, everybody needs to continue to act carefully and remain cautious. Government expects and recommends that people wear face coverings in crowded areas such as public transport, being outside or letting fresh air in, and minimising the number, proximity and duration of social contacts.
Social contacts the like of which one might have at a large dinner of the Commercial Bar Association. Here's the Prime Minister again talking about that final move out of lockdown.
We've got to do it cautiously. We've got to remember that this virus is sadly still out there. Cases are rising. We can see the extreme contagiousness of the Delta variant. So please be cautious. Go forward tomorrow into the next step with all the right prudence and respect for other people and the risks that the disease continues to present.
So the Prime Minister is in isolation. He's asking us for prudence and respect for other people. The guidance is to minimise the duration and proximity of social contacts. And the Commercial Bar Association holds a large dinner that is attended by at least one Court of Appeal judge. That's what we are now being told by a spokesman for the judiciary.
The attendance of social gatherings by officials around this time and the question of whether they were following the guidance is something the public cares deeply about. So I wanted to know whether Sir Stephen Males and his fellow guests had complied with that written COVID guidance at their large dinner.
To control coronavirus, testing and tracing must become a new way of life.
Was test and trace in use as per the guidance? Were the guests wearing masks as per the guidance?
I wear a face covering to protect my mates.
Was hand sanitizer available?
Letting fresh air into enclosed spaces regularly.
Were the windows open as per the guidance?
The spread of the virus.
Given Sir Stephen Males' standing in society, I thought these were important questions, so I wrote again to Michael Duncan at the Ministry of Justice asking them. I also wrote to the Combar administrator and to the barrister who was in July 2021 the chair of Combar. None of them would answer any of my questions about COVID guidance.
By the 5th of July, the Combar administrator was referring to it as a private dinner. So the word private appeared in her correspondence when I started talking about COVID. She was also now saying it was a regular annual event, but we can't find any record of it in previous years.
She also offered a statement to include in any report. We wrote back and said we would like a statement and asked that it include details about the nature of the event, the venue, the number of attendees, who they were, whether a COVID-19 risk assessment was done, we asked for a copy, whether the venue was ventilated, whether the guests had masks on, and whether test and trace was being used. We also asked for a copy of the invitation. But 3 days later we got this. We do not believe that further correspondence on this matter will be productive, and we never received the statement we were offered. 3 days later, on the 14th of July, the Judicial Press Officer Michael Duncan, on behalf of Lord Justice Males, similarly declined to answer any questions. I'm afraid questions about the event are for Combar to answer, not Lord Justice Males, he said. He just attended. He didn't organise it.
So you are asking him questions that really aren't for him. We also asked him about the distinction between his large dinner and Combar's private one. I don't see why they are mutually exclusive, he said. My understanding is that part of the tradition of barristers that dinners are part of their formal training and qualifying process and are usually quite large affairs, despite also being private. Right, so now we're really confused. It was a large dinner of the Commercial Bar Association, apparently with some kind of training element, possibly, according to Michael Duncan, but it was also private. And it was a regular annual event, but it took 2 months for anyone to remember that they'd been to it. And it happened 4 days after the Prime Minister put himself in isolation and begged us all to have respect for others and the dangers of the virus, whilst the official guidance was to minimise the duration and proximity of social contacts. We still wanted to know where it was held, who was there and what was said, but now we also wanted to know whether this Lord Justice of Appeal and his fellow guests were following the COVID guidance, including test and trace, at their large dinner. But nobody we were then in touch with would tell us anything more. But London is full of commercial barristers and judges who used to be commercial barristers. Combar's website says it has 1,800 individual practitioner members. So we started writing to lawyers and judges in London in the hope of finding a Combar member who had also been to the dinner. Now I'm just going to read you some of the replies that we got. This is Lord Falconer, Charlie Falconer, a key member of the Blair government. I've never heard of such a gathering, he says, or anything like it. No one has ever mentioned such an event to me, either by way of invitation or mentioning it as an event they went to or had been invited to. I was not invited, nor did I attend such an event. Your email is the first mention. Sir Bill Blair, who is Tony Blair's brother and a former chair of Combar, says, I am not aware of a dinner. Lord Grabiner, a crossbench peer, says, I've no knowledge of such an event taking place, and as a member of Combar, I would have expected to have heard about it. I don't think your source is credible, I'm afraid. Remember, our source is a spokesman for the judiciary. Leonard Hoffman, the Baron Hoffman, a former law lord, says, I have no knowledge of such an event taking place, and I certainly did not attend one. Baron Collins, a former Justice of the Supreme Court, says, I would be very surprised if it were true. Lord Justice Lewison says, I neither know of such an event, nor have I heard of one.
Stephen Cogley at Four Pump Court, who has been a lawyer for nearly 30 years, says, I am a member of Combar, and if there was an actual dinner, and I think not, and it was a Combar dinner, then I am sure I would have been invited along with the rest of the Combar members.
Matthew Collings at Maitland Chambers says, seldom does Combar arrange jollies. Indeed, I cannot recall one. This was a regular annual event, remember, I was told. I would be most surprised, Matthew Collings goes on, if any such gathering was arranged, and even more surprised if anyone attended. But Lord Justice Males attended, or so his spokesman had told us. Liz Jones, the head of chambers at Searle Court, said, "I have not heard of
Such an event, and I did not attend any such event. It sounds unlikely to me. Events were still being held by Zoom at the time, and barristers are pretty risk-averse people." Stephen G. at Monkton Chambers said this: "The Commercial Bar Association is a law-abiding association. By July 2021, many families had lost family members to COVID, and it would have been inappropriate and illegal to hold such a dinner. I am a member of Combar and have heard of no dinner."
Now, I don't know if he's technically correct there, Stephen G, about it being illegal. Full lockdown had ended, but he's been a lawyer since 1975. He was the head of another set of chambers for 15 of those years. He lectures in law at university level, and he has in the past given lectures to the Commercial Bar Association itself. And that was his gut reaction, that it would have been illegal. And then there was Michael Howard at Quadrant Chambers, who has been a barrister since the early 1970s. "I was quite upset," he says, "because if there was a dinner, I was not invited. Indeed, I have never been invited to any Combar dinner, despite having been a member since its inception. One reason may be that Combar does not hold dinners. Combar is simply not that sort of organisation." A large dinner of the Commercial Bar Association that was a regular annual event. But here's a man who's been a member of Combar since there has been a Combar, and he's telling us that Combar doesn't hold dinners. This next one is from Lawrence Rabinowitz at 1 Essex Court, who is a Deputy High Court judge, and like Sir Bill Blair, he is also a former chair of Combar. He says, "I would be very surprised indeed if that happened, and I am extremely confident it did not." We've got lots more of these replies, and they all say similar things. We also circulated a request via the clerks of most of the commercial barristers' chambers in London and asked them to pass that on to their members to try to find an attendee. Only one of those barristers' chambers got back to us, and that was to say that none of their members had been to this dinner. So we've done about as much as we can to establish whether this spokesman for the judiciary is telling us the truth about this large dinner of the Commercial Bar Association, and I'm afraid the evidence now suggests very strongly that he is not. After considerable investigation, the only two people who have been identified by Lord Justice Mayles as attendees are himself and Duncan Matthews. Personally, I think that the idea that the Commercial Bar Association would have held a large dinner on that day in July 2021 is absurd, and many people who should be in the know about it think the same. Former Chair Sir Bill Blair is not aware of it. Former Chair Lawrence Rabinowitz is extremely confident it didn't happen, and nobody will answer questions about the venue or the test and trace arrangements. The current administrator won't. The former administrator, who I interviewed at her home, won't. The barrister who was the chair of Combar at the time won't. And Lord Justice Mayles, who claims to have attended, won't. So, to summarise, when we asked two British judges about conversations they'd had outside court about a case with a man who wasn't party to it, we were made to wait for 2 months for an answer, and then we were given an account that we find it impossible to believe is true.
Remember what Lord Hope said. The golden rule is that judges do not discuss individual cases. These two judges are both emailing the same person behind the scenes about a case in which he is not involved, and one of them is discussing it with him face to face.
Now, for the reasons we've explained, we don't believe that this discussion took place at a large dinner of the Commercial Bar Association, but even if it had, it would still be a breach of Lord Hope's golden rule, and it would still be a breach of the judge's own code of conduct, which says judges should avoid extrajudicial activities that are likely to cause them to have to refrain from sitting because of a reasonable apprehension of bias. One of them meeting up with Duncan Matthews and talking about a case, both of them sending Duncan Matthews emails about that case. It certainly gives us the apprehension of bias.
To give you a reference point as to where private conversations with judges can lead, let us take you across the world and almost 50 years into the past. New South Wales, Australia, 1977. A Commonwealth country that shares our monarch and, like the UK, has a system of common law. The chairman of the Australian Rugby League, Kevin Humphreys, is facing 9 criminal charges for fraud, accused of taking more than $50,000 from Sydney's Balmain Tigers when he was their club secretary. A big character who was well known as a player, Humphreys was a prominent public figure with some influential friends. A hearing was set for the 11th of August at Sydney's Central Court to rule on whether he should be committed for trial. Just before 10 o'clock that morning, Chief Magistrate Murray Farker held a meeting with the other magistrates in his chambers at the court. When the meeting was over, he asked Magistrate Kevin Jones, who he had chosen to hear the Humphreys case, to stay behind after the others had left. When they were alone in private, Farker uttered the 9 words that would go on to destroy his life. Invoking New South Wales's top politician, Premier Neville Wran, to try to ensure that Jones did not commit Humphreys for trial. "The Premier's contacted me," he told Jones. "He wants Kevin Humphreys discharged." At the end of the 2-day hearing, Jones dismissed all the charges against Humphreys, who walked from court a free man, much to the dismay of the police officers who had investigated him. As the rugby boss celebrated the win at a Sydney bar that evening, he is said to have told a newspaper reporter, "It's good to be able to say thank you to so many good friends who have stuck by me." And that would have been that, but for a documentary team from the ABC's Four Corners programme who stumbled across the story years later. They had set out to make a programme about governance in rugby league and the financial structures of that sport. They ended up making a programme about high-level corruption in court. In April 1983, in an episode entitled The Big League, they revealed the role that Murray Farker had played in the dismissal of the charges against Kevin Humphreys.
Dismissed the charge and Humphreys walked out of the courtroom a free man. Our investigation into this episode has uncovered important new evidence which indicates that a serious interference with the administration of justice may have taken place. We believe that it merits a full public inquiry.
And that is exactly what happened. Within 10 days of the ABC's programme going to air, a judge was appointed by Royal Commission to investigate. And 3 weeks later, his inquiries were underway at New South Wales's Supreme Court. His brief was to determine whether Senior Magistrate Farker had influenced Jones, or tried to, and whether the politician, Wran, had directed or requested that he do so. The judge given that Royal Commission was Sir Lawrence Street. His report, when it was published, cleared Wran, but condemned Farker. After careful deliberation, I have reached the conclusion that in the public interest, the criminal law must be invoked, in vindication of public morality, he said, and in vindication of the integrity which our society rightfully demands and expects in the conduct of those who sit in judgment upon their fellow citizens in the administration of justice. The offence that appears appropriate is the common law misdemeanour of perverting the course of justice. Only 2 people knew exactly what was said in Farker's chambers at Sydney's Central Court in August 1977. No emails, no tape recordings. It was one man's word against the others. In his evidence to the Street Commission, Jones was adamant that Farker had spoken those 9 words. "The Premier's contacted me. He wants Kevin Humphreys discharged." But Farker told the Commission that he mentioned Rann only to warn Jones in a general way about the prominence of the defendant. "I told Mr. Jones," he said, "that the case had attracted publicity and involved a well-known sporting figure who was well connected with high officials, such as the Premier. I said that he should carefully handle the case and be fair."
So the judge's job was to weigh Farker's account against the account of Jones, and he believed Jones. He believed that Farker had spoken those 9 words, and he believed it precisely because of Farker's insistence on speaking to Jones in private. Street said, "If, as Mr. Farker claimed in his written statement, his action was proper and part of my functions, there was no reason for Mr. Farker to have concealed it from the other magistrates. The creation of this situation of privacy is an indication of awareness on Mr. Farker's part of the impropriety of what was about to follow." On Sir Street's recommendation, Murray Farker was charged with perverting the course of justice. He was found guilty by a jury, and he was jailed for 4 years.
An article in the Sydney Morning Herald in 1985 explained that he was held in isolation at Long Bay Prison for his own protection. It seems possible that some of his fellow convicts would have taken a dim view of criminal behaviour by a judge who was presumably on the bench when some of them were themselves sent to Long Bay.
So Murray Farker's insistence on the creation of a situation of privacy was enough to convince a judge and a jury that he had perverted the course of justice and that he had intended to. So our question for the Ministry of Justice is this: if 9 words in one private exchange were enough to put a judge in jail in Australia, what do they have to say about the 3 private exchanges that we've described in this programme? First, there is the heads up from Mrs. Justice Cockrell to Duncan Matthews on the 26th of April, and a copy of her judgment delivered personally to his inbox.
We have not seen the native email or the PDF itself. We have no idea whether it was annotated, and neither do the parties to the case. We would welcome the opportunity to look at that if the Ministry of Justice was willing to provide it. Second, there is the mysterious meeting the other night, on the 22nd of July, we have been told, at which a conversation took place about this case. And at that meeting, Duncan Matthews was aware that Lord Justice Males, one amongst 37 appeal court judges, was dealing with a particular permission to appeal. How had Duncan Matthews found that out? And third, there is the report back from Lord Justice Males to Duncan Matthews on the 28th of July. "You will see how I dealt with this," he says, and sends a Microsoft Word draft of his decision with an internal Court of Appeal office form still attached. Why was Lord Justice Males reporting back to Duncan Matthews, and why was he sending him that document?
3 instances of what Sir Lawrence Street in Australia would surely have described as situations of privacy created by these 2 judges with a man that both of them have known for many years. One wonders what previous users of the British courts might make of these emails. One wonders what future users of the British courts might think about them. Users like Google and Apple, who are being sued in the British courts right now for hundreds of millions of pounds. Our opinion here at Hunt and Gather is that everyone, from the largest corporation right down to the individual facing criminal charges, should care about why these two emails exist and about exactly what happened at that meeting the other night.
Coming up on future episodes of The Other Night, we'll be asking how our inquiries to the Commercial Bar Association about Lord Justice Males ended up on the desk of Mrs. Justice Cockerell and prompted this email to the press office adding detail to the story about the dinner. We'll be revealing what else these judges were saying to the press office during those long delays in answering our questions in the summer of 22. We'll tell you about the other senior judges who knew about these emails and what Mrs. Justice Cockerell said about legal submissions that might have helped these claimants to continue their case. And we'll be digging into some of their evidence which we find compelling and trying to understand how Lord Justice Males reached such a different view. But before we leave the Royal Courts of Justice, for now, here's a message from us. We don't agree with Fidel Castro about much, but when he said the first thing dictators do is finish free press, he was right. There is no doubt, he said, that a free press is the enemy of dictatorship. Those who seek today to control the flow of information to the public have realised that financial coercion of the press, be it directly or through the manipulation of advertising revenue, is less hassle, more effective, and probably cheaper than the kind of coercion Mr. Castro no doubt had in mind. Because the production of free press is not free of charge. The only way journalism can be truly independent is if it's funded by people who only care about the truth. We have no sponsors or advertisers. We have only you. So please, if you've enjoyed this programme, if you think the issues that it raises are important, and if you want to help us get future episodes to air, donate now via one of these methods. Thank you for your attention, and thank you for any help that you can give.